Hi, my name is Bob Nichols. I'm with Bracewell. I'm a labor attorney here. I've had the opportunity to work with or meet many of you. I'm glad you were able to join us today for a discussion of trends and legal changes impacting marijuana and CBD laws, and to some extent, testing for marijuana. This is the third in our trilogy over the last 3 days of presentations related to important areas of legal development with regard to state and local laws. We decided to do this three-part webinar presentation because what we saw, along with our clients, is that the focus of change, the area of change, is not the federal government so much as it is state and local governments. And in fact, some might argue that legislatures and city councils are acting aggressively to some extent in response to the inaction of the federal government, the notion that they need to act to move employment protections forward because the federal government is not. At least that is one school of thought. But for employers who have to assure that the company's policies and practices are consistent with applicable law, changes at the state and local level, of course, are in many ways worse than federal law changes because you're left with a patchwork of different changes that you have to manage. And in your busy worlds, there's nothing more difficult than trying to figure out what you're supposed to do in every different state and jurisdiction in which you operate. With that said, let me turn to our third and final topic, the topic for today, marijuana, CBD, marijuana testing. I want to start with a quick primer on terminology and concepts important to this area. When I've spoken on this topic before, I've just assumed that the listeners have a basic understanding of the different distinctions between such things as THC and hemp and CBD and synthetic cannabinoids. And what I've learned is that assumption is not often correct, and people who join us for these presentations are not familiar with the distinctions between these underlying concepts when you're talking about cannabis and marijuana. So let's discuss the basics. First of all, cannabis is a flowering plant that contains more than 80 biologically active chemical compounds. What are known as, and you see this in the newspaper with discussions of CBD, et cetera, and THC, cannabinoids. Those are the active chemical compounds of anywhere from 80 to 100 in the cannabis plant. And there are different varieties of the cannabis plant that are cultivated in different ways for different purposes. Two of those active chemical compounds in cannabis that we hear about a lot is THC and CBD, cannabidiol. And THC, as most of you know, is the main mind-altering ingredient in cannabis that makes people high, that creates the intoxicating effect. CBD is a cannabinoid that does not have a mind-altering or intoxicating effect, but is believed by many individuals and some healthcare providers to have some medically beneficial effects. CBD is generally not regulated by the FDA like other drugs. The FDA does not vouch for the medical effectiveness or safety of CBD. The National Institute of Health recognizes that CBD arguably may be useful in reducing pain and inflammation, controlling epileptic seizures, and possibly even treating mental illness and addictions. The other benefits purportedly prescribed to CBD are too long to list. And as many of you seen in your local stores, whether they be drug stores or other stores, grocery stores, CBD products are popping up everywhere. And in fact, there are stores in Texas that are devoted almost exclusively to CBD products. The CBD is all the rage, and people believe it cures just about anything and helps about any problem you might have. Again, the FDA cautions that that's not necessarily their view. The FDA has approved a CBD-based liquid medication called Epilex for the treatment of two forms of severe childhood epilepsy. That is the only CBD-based substance which can be found in an FDA-approved drug, and it's for a very limited type of childhood epilepsy. The NIH continues to conduct research into potential medical uses of THC, CBD, and other cannabinoids. In other words, other components of the cannabis plant. For example, the NIH reports that there's now evidence from one-cell culture studies with rodents that suggest that purified extracts from the whole cannabis plant can slow the growth of cancer cells from one of the most serious types of brain tumors. Again, while there are lots of studies going on about the benefits and detriments of THC, CBD, and other cannabinoids, there has been no conclusive assertion other than the one epilepsy drug I described that has some CBD extracts. There have been no firm conclusions that THC or CBD have broad medical benefits. So we turn to the term that we're most commonly used to hearing, marijuana. Marijuana is a variety of cannabis. It's a part of the plant as well. It's not the whole plant. Marijuana is the greenish-gray mixture of the dried flowers of Cannabis sativa, a variety of cannabis. Marijuana, also known by countless slang terms, weed, pot, Mary Jane, etc., is the common cannabis product that has been and is widely used as an intoxicant in the United States and throughout the world. Marijuana contains the infamous THC, the intoxicating component cannabinoid of the cannabis plant, and also contains quantities of CBD along with dozens of other cannabinoids. Marijuana has been included on Schedule 1 of the Federal Controlled Substance Act since 1970. As you know, that when that law was passed as part of the Nixon administration's war on drugs, there was a fundamentally different view of marijuana in this country. We still had sort of the reefer madness view of marijuana users, that it didn't just involve sedate conduct by adolescent boys, but might lead to violent behavior. There were concerns, and it was propagated by the Nixon administration in passing the Controlled Substance Act, that marijuana might lead people to violence and other bad antisocial behavior. So people were very fearful of marijuana at that time, particularly older people. And there was lots of pressure to place marijuana on Schedule 1. Schedule 1 being drugs that are highly addictive, highly dangerous, and have no potential redeeming medical benefits. And logically, marijuana probably did not belong on Schedule 1, but what was done, of course, as many of you have heard from me before in prior presentations, a very studious commission was formed that studied this issue for 4 years, the Schaefer Commission, headed by the governor of Pennsylvania and appointed by President Nixon to this commission to study what kind of problem marijuana really was. The Schaefer Commission issued a report in 1974 and said that marijuana is something akin to alcohol. It has intoxicating effects. It has antisocial impacts, but it is not a devastating drug like LSD or heroin, and that it probably should be decriminalized and treated like alcohol, where abuse is dealt with through typical social conventions like family and friend disapproval, and not through the criminal justice system. Of course, as many of you've heard me say, the Nixon administration and conservatives in Congress quickly and ferociously condemned the Schaefer Commission and said that marijuana must remain on Schedule 1, and it has and remains on there today in 2020. Let's talk about hemp, because we hear the term hemp used in connection with marijuana or cannabis. What is hemp? Hemp is another strain of the cannabis plant grown for industrial purposes. Specifically, hemp is most valuable because of its fiber attributes that make it very useful in making ropes, strong fabrics, and fiberboard. And hemp has a number of other potential industrial benefits. Hemp does include cannabinoids like trace amounts of THC and CBD, but typically includes THC at far lower levels than marijuana. The term industrial hemp became particularly important in 2018 when it was defined in the 2018 Federal Farm Bill, where industrial hemp was made lawful. Interestingly enough, while many state legislatures, the most conservative state legislatures, like Mitch McConnell from Kentucky, like Governor Abbott from Texas, are ferociously anti-marijuana, they are vigorously pro-hemp because they believe that hemp can be an industrial product from which farmers in their state can make lots of money growing. So both the Congress, thanks largely to the leadership of Senator McConnell, and Texas, in a bill signed by Governor Abbott, have legalized industrial hemp. Both of them remain regulated by the federal and state governments, and you're not free to just go out and grow hemp in your backyard, but they, subject to certain regulation, they're now subject to lawful cultivation and use. Importantly, when we talk about industrial hemp, the definition under both federal and state law now is that only cannabis plant products with THC content below 0.3% can constitute industrial hemp. And by the way, under federal law now, products derived from industrial hemp and that have less than 0.3% are not unlawful. So generally, while there remains lots of confusion, CBD that is derived from industrial hemp and has less than 0.3% THC is generally not unlawful under federal law. That doesn't mean it is prescribed or endorsed by the FDA or the CDC, but it is not unlawful under. It's not part of Schedule 1 of the Controlled Substances Act. Contrast the THC levels in industrial hemp with what we typically find in marijuana. The DEA reports that the average THC content of seized marijuana in 2017 was 9.6%. So you can see that the amount of THC in marijuana is many, many, many times what you find in industrial hemp or in most what are CBD products. Notably, this is important, especially for some of you who have teenagers. You might be concerned about this. The intoxicating effect of cultivated marijuana has increased over the years. In the early 1990s, the typical THC content of seized marijuana was 3.4%. In the early 1970s, it was less than 2%. Today, it's risen to approximately 9.6%. And there are strains of marijuana that are in excess of 20%. Additionally, it's possible to cultivate very high level of THC strains marijuana. And that is happening, and therefore, marijuana on the street is becoming more and more potent as time passes. You also hear about synthetic cannabinoids, and what those are not plant-based products, but are synthetically lab-created products that produce the effects that one typically experiences from THC. And a large concern of the DEA is that synthetic cannabinoids are becoming more and more common and more of a source of drug abuse. Stronger forms of marijuana include something called sinsemilla. It's made through a process involving tending certain female plants of the cannabis plant. They have far higher levels of THC than typical marijuana. Also, you can create products that have concentrated levels of THC, like resins that are derived from marijuana with extraordinarily high THC levels, including what's commonly referred to as hash oil. So I've given you sort of an overview of the basics of cannabis. Marijuana does have addictive qualities, and according to the CDC, 1 in 10 individuals who use marijuana become addicted. For adolescents, the addiction levels are far higher. 1 out of 6 become addicted. When marijuana is used in conjunction with alcohol, there's a snowballing effect, and the intoxicating, the impairing effect is much higher. Additionally, using marijuana can distort the proper manner in which certain prescription drugs impact the human body. So if you or you have children who use marijuana and you take prescription drugs, in some instances, marijuana may distort the proper effect of those prescription drugs. How significant is the impairment caused by marijuana, and in particular, the psychoactive ingredient including the marijuana THC? The CDC reports that marijuana use for a period of hours, typically viewed as like 3 hours after use, negatively impacts certain common functions, including, very importantly, key skills associated with driving or operating heavy equipment, such as reaction time, memory, and perception. How the impact of marijuana compares with the impact of alcohol on safety-sensitive functions such as driving or operating heavy equipment is a subject of great controversy. Both drugs have impairing effects. The impairing effects they have are different and difficult to compare. The fact remains that studies show that employers should be concerned in the case of either alcohol or marijuana about persons performing truly safety-sensitive functions that require such things as good reaction time, good memory, good perception, a good hand-eye coordination when either someone's using alcohol or marijuana products. All right. Now that your tutorial on marijuana basics is over with, let's talk about what the public thinks about marijuana, because that's important to understanding what's happening with the law. Some of you might be surprised by some numbers I'm going to share with you. Some of you might not. But while, for example, in the United States Congress, there remains vigorous opposition to marijuana legalization, and in many state legislatures, including most certainly ours here in Texas and Austin, that's not the view of the general public across the United States or in the great state of Texas. 62% of Americans support recreational legalization, according to a Pew Research poll. 89% of Americans support medical legalization, according to a Quinnipiac University poll. According to a UT Austin poll from last year, 54% of Texans support recreational legalization. And that UT poll indicates that 83% of Texans support medical legalization. So the public has left 1970 and does not have the views about marijuana that we once did. And a clear majority support recreational legalization both in our state and across the country, and an overwhelming majority of Texans and Americans support medical legalization. No state serves as a better example of this turning tide than Oklahoma. For a period of years, marijuana legalization advocates in Oklahoma tried to convince the Oklahoma legislature to pass at least medical marijuana legalization measures. For example, Representative Proctor from Tulsa introduced House Bill 1877 into the 2017 legislature seeking to legalize medical marijuana, and it went absolutely nowhere. The very conservative legislature in that state was not anywhere close to accepting even medical marijuana. Then along came the opportunity for a referendum in Oklahoma, which is allowed under Oklahoma law, like it is in a variety of states. And in June 2018, Oklahoma voters overwhelmingly approved medical marijuana. 57% of the voters in Oklahoma. So you have a very conservative Congress, and you have very conservative legislatures, often lagging behind a public which is becoming increasingly accepting of marijuana. And all of this creates problems for you as employers, particularly with regard to safety-sensitive functions, and we're going to discuss those in greater detail. Again, while you have overwhelming support for at least medical marijuana legalization, and certainly majority supporting even recreational legalization, we remain in a world where not only is marijuana still legally impermissible, but in theory you can go to jail for even small portions of marijuana in your possession. Under federal law, under the Controlled Substances Act, You can still, under the sentencing guidelines, face up to 1 year in prison for first-time possession of a small amount of marijuana. I'm not suggesting that the prosecutor is likely to pursue that remedy, but that's what you could face. First-time possession of a small amount of marijuana in Texas still can result in up to 180 days in jail. Importantly, and many of you are very aware of this, one big practical danger for an individual becoming involved in marijuana is their employability, because now with almost the universal use of criminal background checks, individuals who even have minor marijuana convictions or prosecutions can have great difficulty finding employment in many industries, especially more lucrative jobs with larger companies. So both in terms of employment and in terms of criminal prosecution, we lag behind, I think, where the public is on marijuana. But many states are beginning to catch up with public views. Most states now permit medical marijuana use, at least under regulated circumstances, and there are some states like Texas and many of the southern states in the southeast, that permit low THC cannabis products for some medical purposes. You know, in Texas, many of you may have read in the paper, oh, we now allow medical marijuana. Well, that's not exactly right. We allow use of a highly regulated, very low THC product for certain very limited medical conditions. The number of states allowing recreational use is increasing rapidly as well. There are now 11 states permitting such use and more coming. Illinois was the last state. Their law becomes effective January 1, 2020. States very close to us, like New Mexico, are certainly on the cusp of recreational legalization. Florida is close. There are a variety of states. There is no doubt that in 5 years, this 11-state number will be 20 or more. It's going up, and it's going up fast, and so that is the future. And in fact, I think it's safe to say where we're headed, when you look at the generational polls, where millennials are, for example, on marijuana, there is little doubt that where this train ends is almost certainly with national legalization for both medical and recreational purposes. It's just a question of how long it takes us to reach that spot. Okay, here are the states that allow for recreational use. They all also, of course, allow for medical use. And that number will grow. Here's a map that we, with the help of our graphics department, we've created that sort of reflects the current status. You see the dark blue states are recreational and medical use states both. The aqua green is full medical marijuana use, not like Texas, because we don't really allow people to smoke or use true marijuana. We have a low THC product instead, but many states allow full medical marijuana use, and most of them allow people to have joints and smoke their medical marijuana. Some states do not, and some states like Texas don't even really have conventional medical marijuana. We'll talk more about what Texas has. And you see those low THC CBD states in the light green. And then in the light blue, there are some states that continue to say, you are not to use any form of cannabis in our state, period. Let's talk about what happened in Texas this summer. On June 14, Governor Abbott signed a bill that created a significant expansion of the state's compassionate use program. Starting in about 2015, we allowed low THC use for a very narrow type of epilepsy. The list of conditions for which that low THC product can be used grew as a result of the 2019 bill. The law now allows the use of that low THC product for multiple sclerosis, other seizure disorders, autism, cancer, and other incurable neurodegenerative diseases like ALS, Alzheimer's, Parkinson's, Huntington's disease, and others. Notably, the author of this bill was a Republican from Fort Worth and a nurse, Stephanie Glick. And again, interestingly, a number of the most pro legalization members of the Texas legislature are Republicans. There was a real move to largely decriminalize completely the possession of small amounts of marijuana in Texas during this last legislature, but our Lieutenant Governor, Dan Patrick, refused to allow the legislation to advance, even though there was overwhelming support for it in the legislature. So, which, to editorialize a little bit, is probably unfortunate because it's awful to see some young person have their life inexorably changed because of some possession of a very small amount of marijuana. But that remains a concern in Texas. You still face up to 180 days in jail the first time you're caught with that very small amount of marijuana. To qualify for legal cannabis, the patient under the Texas law must obtain a prescription from a qualified physician who is board certified in the area at issue. So often with a lot of these conditions, you're going to have to go to a neurologist or an oncologist, whatever the applicable specialty may be, to get the approval. That's a relatively elaborate process to get approval from the state. We do not have a very generous or broad THC medical use program. And of course, even when using that low THC product, you cannot use it in a smokable form. You rub it on as an oil or what have you, but you cannot smoke it. The product used under that low THC product under the Texas law has to be less than 0.5% THC by weight, which means it's nothing more than glorified CBD. It's got a tiny bit more potency than CBD. As a result, the product used again is little different than 0.3% Texas or in state and U.S. Farm Bill CBD at 0.3%. I expect you'll see the Texas program expanded and the requirements loosened in future legislatures, but we did advance to some extent for those who support medical marijuana use in this last session. The law explicitly on CBD has changed in Texas. We had this bizarre situation for a period of years in Texas where there were all kinds of stores offering CBD products, CBD makeup, CBD edibles, CBD oil, CBD skin treatments. And CBD arguably remained illegal in Texas. And Governor Abbott and the legislature wanted to correct that disconnect. And so with House Bill 1325 that Governor Abbott signed on June 10, CBD becomes lawful as long as it comes from the industrial hemp product we described, which contains less than 0.3% THC, and the CBD product has to be below that 0.3% level. And CBD, in theory, still is supposed to be relatively highly regulated under our state law. Though I note that while it remains relatively highly regulated, how you're supposed to be able to sell CBD, you still find it for sale everywhere. And I don't think a lot of these retailers are doing so in a manner consistent with or pursuant to the regulatory process provided by the state law. But I don't think that that's a major concern for state prosecutors. As many of you know, in a lot of jurisdictions like Harris County and Bexar County, district attorneys are having a terrible time even prosecuting routine marijuana cases because we now allow this 0.3% CBD product, and they don't have the lab resources often to distinguish between lawful CBD and unlawful marijuana, and therefore it has greatly slowed marijuana prosecutions in many parts of the state. So the least of their concerns is going after your CBD cream, and the fact remains that the fact is that CBD is largely lawful now under Texas state law. Like the Federal Farm Bill of 2018, the Texas law limits permissible hemp products, including CBD products, to those containing a THC level concentration of no more than 0.3% on a dry weight basis. None of the state laws prohibit employers from testing for marijuana except Nevada, and also one major municipality, New York City, largely prohibits marijuana pre-employment testing, and we'll talk about the Nevada law and the New York City law. None of the state laws prevent an employer from prohibiting off-duty use from prohibiting on-duty use or possession. So let me emphasize, you do not need to allow employees to have medical marijuana products or at work. You do not have to allow use at work, and you do not have to permit impairment at work or on duty from medical marijuana. None of the state laws prevent an employer from prohibiting employees from being under the influence while on duty. The problem is this: how do you determine when someone's under the influence? The studies show that the kind of indicia that you're supposed to look at to recognize that someone may be impaired by marijuana is the same type of indicia that's created by such things as a divorce, a troubled child, an upper respiratory illness. So how do you determine whether someone's lack of sleep, red eyes, slowed responses is the result of medical marijuana or simply the result of an everyday life problem that we all face? So spotting someone through their behavior as a marijuana user at work is a real challenge and often leads to negative reasonable suspicion tests. There are differences in the state laws that have legalized marijuana for medical purposes, whether marijuana is legalized for both recreational or medical use or restricted to holders of duly licensed medical marijuana. That is one big difference between the states, as we discussed. You saw that from the map I showed you. Circumstances under which medical marijuana licenses may be granted vary widely. Some states have very elaborate, difficult processes for getting a medical marijuana license. Some states make it very easy. Some states limit the conditions for which medical marijuana license can be issued to a very small list. Like there are 9 very specific limited conditions under the Ohio state law that allow for a medical marijuana license. In other states like Oklahoma, the law is very broad, and almost any medical condition where the physician deems medical marijuana helpful can lead to a medical marijuana license. As you've heard me say, in a variety of states, including, for example, New Jersey, anxiety is one of the conditions that allows for the issuance of a medical marijuana a license. So in some states, medical marijuana laws are very broad in terms of covered conditions. Other states, they're very limited. Obviously, our low THC law has a very discrete, limited list of conditions in Texas that qualify for a license. Very importantly for you as employer representatives, these laws sometimes have no protections for medical marijuana users with regard to their employment, and some of them have protections, but varying types of protections. For example, some states like Oklahoma, like now New Jersey, like a variety of other states, have provisions that prohibit discrimination against someone because they're a licensee. So in those states, you couldn't say, we don't hire any medical marijuana licensees. Though many states, like Oklahoma, have an exception for certain safety-sensitive positions. Protection from adverse action due to failed drug tests is a provision that exists under some state medical marijuana laws. Also, some state medical marijuana laws or some state disability discrimination laws require reasonable accommodation of off-duty medical marijuana use. And now some states, like New Jersey, require you to follow a process after an employee returns a positive marijuana test to basically check if the marijuana test was the result of lawful medical marijuana use under their state law. And we'll talk more about what New Jersey did just this summer in that regard, because it's probably a harbinger of things to come in other states in that regard. Now, I mentioned that two jurisdictions of note have substantially limited employers' rights to conduct pre-employment marijuana testing. On June 5, Nevada passed a law that generally bars pre-employment marijuana testing, but it has some exceptions. And it is one exception, which is giant. It has some narrow exceptions, like the fact that the law does not apply to pre-employment testing of firefighters or EMTs. But very importantly, it also provides that if the employer makes a determination that a position could adversely affect the safety of others, basically it's a safety-sensitive job, then in Nevada, you can conduct pre-employment marijuana testing. The problem is what does that mean? And what will the courts of Nevada say that means? Is someone who drives from one of your offices to the other office in Las Vegas or Reno, are they in a safety-sensitive position? Or would that not qualify? We don't know. It seems to be that Nevada tried to confer relatively broad discretion on the employer to make that determination. New York City has also, in a bill that became effective on May 10, generally banned pre-employment marijuana testing in the city for employment, applicants and employees, to begin on May 10, 2020. There are certain exceptions like in Nevada, but they're not as broad in Nevada. And the rationale that came out of New York City, out of their city council, was that it's reasonable to treat marijuana just like alcohol. And because after all, there's relatively broad permitted use in New York City, and why should you require someone to sit for a pre-employment marijuana test when you in fact on DADA can't do pre-employment alcohol testing? We should expect that other jurisdictions will follow, some additional jurisdictions will follow Nevada and New York City and largely limit, or if not outright ban, pre-employment marijuana testing. I want to talk about some notable decisions that have arisen and in the context of protections in employment for medical marijuana users. Let's briefly talk about the 2017 Callahan case. Let me tell you that we saw a real change in 2017. I've been talking about marijuana, medical marijuana in the workplace for over 10 years. And in the early years, it was pretty easy for employers to deal with this because states that address this issue of employment protections for medical marijuana users early, like California, Washington, Colorado, seem to almost uniformly say, look, there are no employment protections. You can use medical marijuana in our state, but as for what your employer does, you proceed at your own risk. Your employer can still fire you for that authorized medical marijuana use. In 2017, we just saw a sea change as state legislatures and courts in states began to pass or adopt positions that restrict employers' rights to punish people for lawful medical marijuana use under their state law. The Rhode Island law had a provision that said no employer may refuse to employ or otherwise penalize a person solely for his or her status as a cardholder. But the law went on to say nothing in this chapter may be construed to require an employer to accommodate medical use of marijuana in any workplace. Okay, the gist of the Callahan case is the employer took the position we can punish people for using medical marijuana, we just can't punish them for having a card. And what we've seen in the Callahan case and other cases is when would-be clever labor lawyers have tried that argument, courts understandably have said, wait, let me see if I've got this straight. The law says you can't punish people for having a card, but you can punish them for using the card. And as you might imagine, judges have been more than skeptical about that argument and have generally rejected it. And the court granted summary judgment for the employee in Callahan. An employer cannot refuse to employ a person due to his or her status as a cardholder, and the right may not be denied due to the medical use of marijuana. So you can't saying you can't punish someone for being a cardholder, of course, naturally means you can't punish someone for using marijuana pursuant to the card. The employer did not contest that it denied the plaintiff, a medical marijuana cardholder, employment on the basis that she simply admitted, in this instance, Callahan admitted she couldn't pass a pre-employment drug screen. The Whitmire case out of Arizona is interesting. It involves Walmart. Following an on-the-job injury, the medical marijuana cardholder tested positive for marijuana metabolites. As a result, Walmart terminated her employment. The employee sued under Arizona's medical marijuana statute. The court had to reconcile some language under Arizona law. First of all, the statute permits an employer to take adverse action based upon a good faith belief that an employee was impaired by medical marijuana on the job, okay? But it generally prohibits discrimination against a cardholder based on their status as a cardholder. The Arizona court read those laws together to indicate that a good faith belief, in other words, to reject someone based on the fact that you believe they were impaired at work, in the case of a positive test, requires the employer to prove that the test showed the presence of marijuana metabolites in a level sufficient in concentration to cause impairment. Drug tests, marijuana tests don't test for on-the-job impairment. You may have a person who never uses marijuana on the job, only uses it in their garage in the evening, and still test positive on a workplace drug test. So this Arizona court said, well, if you're acting based on a positive test, you have to show the concentration was high enough that it basically shows they must have been high at work. And the science to do that just doesn't exist. And the court said to prove that level of impairment, that level of concentration, certainly Walmart needed expert testimony, and you didn't designate an expert witness on that issue, so you can't win because you can't meet your burden of proof. So the court ruled for Whitmire. What we see is this increasing opposition by judges to efforts to punish employees for medical marijuana use in states that permit that use. It'll be interesting to see if there's a judge like that in Texas waiting out there to reach that conclusion with regard to our low THC law. Let's talk about the Knopfsinger case out of Connecticut. That involved their medical marijuana statute. An employer rescinded a job offer on the basis of the applicant's pre-employment drug test, which was positive for marijuana. Knopfsinger was like this classic example about how not to do things. I think, as I recall, Knopfsinger explained she would test positive. They told her, go ahead, still take the test. She tested positive, and in the meantime, they let her begin work. And I said, oh, gosh, you tested positive, you're fired. After she told them, look, I'm a medical marijuana user, I'm going to test positive. So sort of a case study in how not to conduct your HR duties, but in that instance. The Knopfsinger arguments raised by the employer were essentially preemption arguments. They said, look, the federal law, Controlled Substances Act, makes it criminal to use marijuana. So that must preempt our Connecticut state law to the extent we're supposed to allow people to use medical marijuana. And courts have rejected those preemption arguments based on the Controlled Substances Act. So the fact is that the Controlled Substances Act makes it criminal to use marijuana, but that doesn't mean you can ignore state laws that protect medical marijuana users. The court in Knopfsinger also said the ADA does not preempt the state's anti-discrimination law provision related to medical marijuana users. Because after all, the ADA says it doesn't protect people who use drugs unlawfully. So the employer argued, well, that means the ADA preempts our state medical marijuana protection. The court said, we don't buy it. The court found the employer's arguments absurd because the act of merely hiring a medical marijuana user does not itself constitute a violation of the Controlled Substances Act or any other law. In a subsequent Knopfsinger decision, and in that same case, the court also rejected the argument that a federal contractor covered by the Drug-Free Workplace Act doesn't have to follow state law protections for medical marijuana users. The Drug-Free Workplace Act does not require you to regulate off-duty medical marijuana use. And it doesn't protect you if you mistreat, if you fire someone for lawful state medical marijuana use. So these arguments that we kicked around a lot 3, 4, 5 years ago that, well, if they create protections in some states for medical marijuana users, we'll just argue their protections are preempted by federal law and we don't have to follow them. Those preemption arguments have failed pretty much uniformly across the country. The Controlled Substances Act, as these decisions have indicated, does not preempt state medical marijuana protections. The Drug-Free Workplace Act does not preempt those protections, and the ADA does not preempt those protections. Now, I do want to emphasize that for those of you who have DOT-regulated drivers, or for example, DOT-regulated pipeline workers, or railroad workers, or pilots, where the DOT does require drug testing, marijuana testing, you are still subject to those requirements, and to this extent any state medical marijuana law may be inconsistent, federal law does prevail there. So someone cannot say, I get to drive my semi-tractor trailer for work, even though I'm using medical marijuana, because there's a state statute that says I can use medical marijuana. The DOT regs still control with that DOT-covered driver. Bear in mind that some states, even where there is not a state law that provides explicitly for protection for medical marijuana users, has found an implicit protection, either under the state law generally, or under the state's medical marijuana use law, or under the state's anti-discrimination law with regard to disability. This has happened in Rhode Island, Connecticut, Delaware, Arizona. And again, what courts have found again and again is that if a state has a law that says you cannot discriminate against someone based on their status as a cardholder, that means you can't prevent that cardholder from actually using medical marijuana pursuant to the card. In the Barbuda case out of Massachusetts, we found an example of where protections were found for a medical marijuana user where there was no explicit state law protection. And the marijuana state, the Massachusetts state statute only contains vague language prescribing the denial of any right or privilege shall not occur for making use of the state statute for medical marijuana. And also, there's state law that says that the marijuana law does not require any accommodation of on-site medical use of marijuana in any place of employment. Well, what the Massachusetts court found is therefore there was an implicit potential accommodation protection for off-site medical use of marijuana. And so we have this key distinction that you can still prevent employees from using medical marijuana at work or being impaired by medical marijuana at work, but you cannot prohibit them in some states, in some settings, from engaging in off-duty medical marijuana use that does not lead to on-duty impairment. And because impairment generally lasts, many experts say, something like 3 hours, if someone with glaucoma smokes a joint at home in the evening where they're doing so lawfully in their state, pursuant to the medical marijuana law in that state, they are going to show up for work and they are not going to be impaired by marijuana. And in many states, you cannot punish them for that medical marijuana use. I want to talk about the New Jersey case because it's led to some interesting additional developments in New Jersey. In March of 2019, a New Jersey court held that the New Jersey Compassionate Use Medical Marijuana Act that nothing in that statute requires an employer to accommodate medical use of marijuana in the workplace, but the court found that the employer may be required to accommodate under a separate New Jersey law, the state anti-discrimination law for disability, the equivalent of the ADA, the New Jersey law against discrimination. And therefore, the court said you have to consider whether you have an obligation under our state disability law to accommodate medical marijuana use. What happened as a result is, first of all, that decision in Wild is on appeal. But while it was on appeal and after it was decided, the New Jersey legislature acted, and we're going to talk about that action in a minute. Again, it's important for you to realize that even if you have a state where there's no explicit protection in employment for medical marijuana use, there may be an implicit protection found by a court, or they may be a protection found under the state disability anti-discrimination law. Interestingly, this summer, New Jersey acted over the decision in Wild because the business community in New Jersey was very upset. They want Wild reversed. They don't want there to be employment protections for medical marijuana use in New Jersey. But the Democratic governor and the Democratic legislature of New Jersey acted this summer to make the issue moot. On July 2, Murphy signed a bill revising the state's medical marijuana law to adopt and expand upon the protections provided for in the Wild decision. The new law specifically bars businesses from taking adverse action against an authorized medical user if that adverse action is based solely on the employer's status as a cardholder, which again, as we've learned, means that, and if that cardholder actually uses medical marijuana pursuant to that card, you can't punish them for that. The amendment by its terms has not impacted employers' right to regulate on-the-job impairment possession or use. Now, interestingly, very interestingly, the new New Jersey law establishes a procedure that an employer has to follow after a positive drug test for marijuana. The employer must give the individual written notice first of the result before they take any adverse action, and give that person an opportunity to supply a legitimate medical explanation for the positive marijuana test. The employee then has 3 days to provide a medical explanation. This revised New Jersey law is very likely to become a model in other states where they are going to require you to inquire if they have a medical marijuana law in their state. They're going to require you to check with the employee or applicant who produces a positive result for marijuana as to whether the result could have been the result of them lawfully using medical marijuana in their state before you take adverse action. Importantly, the list of states providing explicit employment protections, now including New Jersey, continues to grow. There's New Mexico, Arizona, Arkansas, Connecticut, Delaware, Maine, Minnesota, Nevada, New York, Oklahoma, Rhode Island, Massachusetts, and Delaware all have explicit protections for medical marijuana cardholders with respect to employment. And again, a variety of other states have found implicit protections for those cardholders. Many of you, again, may think that this is largely based upon the states you've heard me mention, some bi-coastal concept where liberals in the Northeast and on the Pacific Coast are adopting these marijuana laws, and in the good old conservative South Plains of the United States, we don't need to worry about that stuff. But that is certainly not the case. We've talked about Oklahoma, Arkansas, New Mexico. They all have medical marijuana laws, broad medical marijuana laws, with some employment law protections. Now, in Arkansas, Oklahoma, and New Mexico, there are carve-outs to allow you to take adverse action with regard to persons holding certain safety-sensitive positions. The problem is that exception for safety-sensitive positions in those states is different in each state. Their definition of what is an accepted safety-sensitive position varies. So if you have operations, for example, if you're an oil and gas company and you have operations in those states, you're going to want to look at what safety-sensitive positions under that state law are such that you can still test for marijuana and not have to worry about whether the person is a cardholder. The idea is even if you're a lawful medical marijuana cardholder, you should not be driving a forklift or operating heavy equipment at an oil drilling site, irrespective of the legitimacy of your use of medical marijuana. Again, those laws vary with regard to what is a safety-sensitive position. In Louisiana, while it doesn't have explicit employment protections, does have a medical marijuana law that they continue to try and implement. Again, as you can see from this slide, the standards for what is a safety-sensitive position such that you can hold medical marijuana use against an employee varies in Arkansas, Oklahoma, and New Mexico, which represents a challenge for HR professionals and in-house counsel with responsibility for operations in those states. All right, I want to turn to some final pieces of recommendation for how you should proceed going forward. First of all, one thing you should take away from this is in any state, if someone produces a positive test for marijuana as on a pre-employment or incumbent employment basis, before you take adverse action, if there's any indication that they used marijuana medically pursuant to a state statute, you're really going to need to confer with counsel as to whether you can go forward and take adverse action. It's just too complicated to have some simple rule where an HR business partner in Tulsa or in Santa Fe can know what to do without the advice of counsel. Even in Texas, where we have low THC, while we don't have an explicit protection for employees in Texas, how do we know that a judge in Austin is not going to find one implicit in the law? So even in Texas, if you don't have to terminate someone for lawful medical marijuana use, low THC product use under state law, you may very well not want to terminate them because you may not want to be the test case. In other words, taking adverse action against a medical marijuana user lawfully using that substance under state law has become very complicated everywhere. And you shouldn't fire that medical marijuana user or refuse to hire that medical marijuana user until you've conferred with counsel. That's how complicated it's gotten. Same thing with CBD. If someone reports that they use CBD and you want to get rid of them because you think CBD is bad and evil and you don't want it, you better check with counsel. Let me say one thing, for example. A doctor might tell someone, I think you should use CBD for your pain or your insomnia. And remember, some CBD in Texas is lawful now. So that CBD is not an illegal substance under the ADA or under Texas anti-discrimination law anymore. So you might have to accommodate that CBD use. And you might have to accommodate the low THC use by someone who's followed the Texas statute. So you should not assume that you can take adverse action against someone based upon CBD use. If you want to try and take adverse action, you better consult with your attorney concerning those specific circumstances and that specific jurisdiction at that point in time. My general advice is someone who hasn't produced a positive test for THC, as I'm going to discuss in the next few minutes, I wouldn't be firing them simply over CBD use for something they got at Walgreens. I do think that one thing you may want to do in your policies is consider cautioning employees that if you produce a positive test for marijuana on our drug testing program, don't think you can use CBD as an excuse. Don't say I should get out of my positive medical marijuana test because I was using CBD cream I bought at CVS. First of all, the chances of that being true are virtually zero, and you're not required to accept that explanation, and you shouldn't. And you should let employees know, don't come to us with that excuse if you pop positive for marijuana. At the same time, clients come to me and say, Bob, what should we say in our policies about how we regulate CBD? I would not try and put a prohibition on CBD use in your policy. I would not try and explain what your position on CBD is in your policies because it's just too complex. And first of all, if they're using properly processed CBD products, it's going to be below 0.3% THC, and it just doesn't represent a risk or concern for your workplace anyway. And what's more, the law is too much in flux and too complicated for you to be trying to regulate employee CBD conduct. Continue to worry about marijuana, not so much CBD. Bear in mind that CBD use, again, might require you to consider reasonable accommodation under state law. If a doctor, for example, says someone should be using CBD, saying, well, I'm not going to allow you to use CBD might violate our state or federal anti-discrimination laws with regard to disability. While the Texas law and other state laws allowing for either medical marijuana use or low THC product use do not include explicit employment protections, again, you cannot be assured that at any point in time, like a judge in Texas won't say, we find an implicit protection. In states where the designation of safety-sensitive positions is important, like Oklahoma, Arkansas, and New Mexico, you should know ahead of time what your position is on what positions you view as safety-sensitive and exempt from their protections for medical marijuana users. And remember, you can still regulate on-the-job medical marijuana use, possession, and on-the-job impairment. If you use an MRO as part of your drug testing program, make sure that they are addressing the issue with a positive marijuana test as to whether the positive test may have been the result of lawful medical marijuana use under state law. You want to be dealing with that issue in conjunction with your MRO. That's all I have for today. I'm told I've used up all my time, so if you have any questions, I'll get back to you. You can put them in the upper right-hand corner box, and I'll call you or email you with an answer. I hope this was helpful. I enjoyed talking to you about this very interesting topic. We enjoyed having those of you who participated in 2 or 3 of our segments over the last week participate. We hope you found it valuable, and have a great day. Thank you.